How does a court decide how to split your house and your money when you divorce? I'm Barrister Daniel Barnett, and I'm here to answer that question for you with the help of Lucy Reed, a barrister from St John's Chambers. Lucy is the author of the really helpful book, The Family Courts Without a Lawyer. Lucy, how does a court decide what to do when a divorcing couple who can't live together anymore decide they have to split up and they can't agree who should get the home and who should get the majority of the marital assets? What factors will a court take into account when deciding what to do?
Sure. So the court has the assistance of the law in this area to tell it what it needs to do, and the piece of law that people need to look at if they want to think about the process the court goes through is Section 25 of the Matrimonial Causes Act 1973. In Section 25 there is a checklist of factors that the court has to think about in every single case. The way in which they're weighed up in each case will be different because every family's circumstances is different. The first thing the court has to consider in any case is the welfare of any children of the family. And a child of the family will be the children of the couple themselves, but also might include any stepchildren they've brought into the marriage with them who they've treated as part of the family. So that's the first consideration that the court has to think about, is the income, earning capacity, property and other financial resources which each of the parties to the marriage has or that they're likely to have in the foreseeable future. And that will include their earning capacity, any increase in that capacity that the court thinks it might be reasonable for them to make efforts to achieve. And obviously that will vary with each case. The next factor the court has to consider is the financial needs, their obligations and the responsibilities of each party, both now and in the foreseeable future. The court has to also think about the standard of living that the family enjoyed before the breakdown of the marriage, and it stands to reason that when the court and divorcing spouses are trying to pay for two households with the funds that they previously had to run one household, they may not be able to achieve the same standard of living. The court has to consider the age of each party, the duration of the marriage, any physical or mental disability of either of the parties, and the contributions which each of them has made. And that isn't just financial contributions, the breadwinning part of a relationship, it's also care responsibilities and other input to the marriage and to the welfare of the family. The court has to consider the value to each of the parties to the marriage of any benefit which the party might lose by the ending of the marriage. So it might be things like spousal benefits. And then perhaps the most difficult factor for parties sometimes to grapple with is bad behaviour. Now in the Act that's described as conduct, and what the Act says is that the court only has to take into account conduct of the parties if that conduct is such that in the opinion of the court it would be inequitable to disregard it. Now what that means is that conduct, bad behaviour, is not going to change the outcome of a splitting of the assets unless it's such obvious and gross bad behaviour that it really just wouldn't be fair to ignore it. In most cases there is some kind of bad behaviour that's led to the breakdown of the relationship. That might be adultery, it might be domestic abuse, it might be all sorts of things. But generally speaking, that conduct is not going to affect the distribution of the assets and the income. So that's the checklist that the court has to go through. And all of those factors have to be weighed up, and the court then has to exercise its discretion as to what's the appropriate thing to do with the house, the income, any other resources that the parties have got, bearing in mind their debts, etc., etc. And in many cases, there isn't probably quite enough to go round, or it's going to be a bit of a squeeze to work out how best to make sure that everybody's housed and has the basics that they need. And so the financial needs of the parties is going to be, in lots of cases, the most important factor for the court to work out how to distribute the assets and the income. And if possible, the court will try to make sure both parties are housed, will try to make sure that both parties have got enough of a budget in order to manage their basic expenses.
Let's take a typical nuclear family, Lucy Reed, with a mum and a dad and 2 children. Is there any presumption in a court that the mum will get the children and so the mum will also get the house?
No. There is a separate piece of law that will deal with any dispute in relation to where the children should be living. It's right to say that, I guess, in still the majority of households, perhaps less than it used to be the case, the mother will be the one with the primary care responsibility, and that may well continue after a separation. But there are many cases where either the arrangements were different during the relationship, or the other way round, or where there will be, for various different reasons, a change in those arrangements once the relationship has broken down. Obviously, the court, when it's deciding what to do with the financial assets, has to make sure that wherever the children are living, whether that's with one parent or the other, or based partly in both homes, there is sufficient housing to meet their needs, so they've got somewhere suitable to sleep, insofar as the finances will allow that. But even where, let's say, the children are living with the mother and they're going to spend time with their dad, of course the court, if possible, is going to want to try and make sure that the assets are divided so that the father may not be the primary carer of the children, but there's somewhere for the children to stay. But if the resources don't permit that, then probably the main base of the children is going to have to be prioritised. The court has quite a wide range of powers to, having made an assessment of what distribution of assets and income there should be, it has quite a wide range of powers to make that happen. The court can order a sale of a property, it can order the distribution, then how the assets should be distributed once the sale has gone through. It can make orders in relation to who should have conduct of the sale and how that should be dealt with. The court can order the transfer of various different assets, and it can also order the sharing of pensions. So that very often there's a disparity in pensions and those can be shared. One of the things the court can't do is to change who is responsible for a particular debt. So the court will have to get to a readjustment where one party perhaps is left holding all of the credit card debt or the other debts by adjusting other assets so that that's offset.
Lucy Reed, thank you. And if you enjoyed this video, please do look at the others on this YouTube channel. I'm putting together a series of explainer videos for English law across all different areas of English law. Please do subscribe. Please do click the notification bell, which you'll see just below. I'm Barrister Daniel Barnett. Thank you for watching. Bye-bye.